All right, with regard to unresolved and contentious issues, okay, the fund will tell you that if you can reconvey the property to the life tenant, and there's no specific language in the deed, they're not going to allow it, meaning the life tenant cannot reconvey the property to themselves. So what if you put language in the deed and make it very specific? Well, the fund will also say that they're not going to allow that. They're afraid of litigation with a remainderman or with a creditor, and they feel it's inconsistent with the grant itself. It's almost like an illusory kind of grant. So I started thinking about that while I was writing this material, and it occurred to me. You can put a provision in a ladybird deed to commit waste. So let's suppose you have a piece of property and it's worth $1 million, and 900,000 of it are trees. And the life tenant just cuts the trees and sells them and keeps the profit. And so when he dies, a remainderman gets a piece of property worth 10% of what the full value was. The fund would say that's fine because you have a provision to commit waste. But if you put a provision in your ladybird deed, and it says very clearly that the life tenant can reconvey to themselves, so now you're divesting the remainderman of 100%. So what's the difference? 10%. So one case you can do it, in the other case you can't. I don't really see why. Seems to me there's no consideration for the deed to begin with. You have a provision in the deed to commit waste. Why can't you have a provision to reconvey? It seems it's just as illusory one way or the other. So I think that's an area we need to look at. As far as judgments against the remainderman, the fund has expanded the position. If it's a simple money judgment, they'll insure over it if the life tenant wants the deed out. If it's a larger judgment, they want to make sure it's a bona fide sale. Or if the mortgage, it's a bona fide mortgage. With regard to Medicaid planning and homestead property, we normally use ladybird deeds in that type of planning just because it avoids probate. With regard to Medicaid and elder law, homestead property is exempt when you're alive and it's exempt when you die because creditors cannot reach homestead because it's protected. But we also use ladybird deeds for non-homestead property, which, while it may be protected while you're alive because rental property is a Medicaid exception, it's not protected when you die because rental property is not protected by the Florida Constitution. But if it passes outside of probate, it will be, because we do not have this augmented estate concept in Florida yet where we can go after everything that goes outside of probate. Now it's interesting because in the Medicaid manual, they actually have a provision on ladybird deeds. It's very specific. They use the term enhanced life estate deeds, ladybird deeds, not very lengthy, but it makes it clear to the caseworker that this deed is fine and you shouldn't have any problem with it and you shouldn't consider it a transfer of assets. The interesting thing is they have another provision in the Medicaid manual that says life estates are freely transferable. So again, I started thinking, well, you know, if you look at those two provisions, on one hand you could create a ladybird deed, and on the other hand you could then transfer the retention of that life estate to that remainder beneficiary, because there's no place that it says you can't do that. So I don't think that's what was intended, but I don't think they've drafted it so tightly that it basically excludes the transfer of a life estate deed. So I think there is some opportunity there, and I do know some attorneys that actually have done that type of planning. I think it's a little risky. I think it needs to be cleared up. I really wouldn't care if they rewrote the manual and tried to clarify that, but the way it's written now, you could create a ladybird deed and you could transfer the life estate later on. Vested versus contingent remainder. Again, the fund says it's a vested remainder, but it could be contingent. Why not draft a ladybird deed so it basically says the remainder interest shall not vest until the death of the life tenant? Why can't you draft it that way? And if you could, then we would be a lot more secure with judgments against the remainderman because it wouldn't vest until death. Again, it seems like a plausible way to draft the deed, something to look at in the future. Those are some of the open issues. The conclusion I have, and I actually think I'm just about out of time, is when you're thinking of doing a ladybird deed, think very carefully what you're trying to accomplish. Think what alternatives you might have, whether a revocable living trust is a better idea, or also think, because of all the possible consequences, you might want to draft a letter that your client signs where you've outlined what could happen with regard to judgments and federal tax liens and other issues, and maybe have the client sign it so they don't come back to you later on and say, you know, you didn't tell me that I have a problem now because my son died and now we have to probate his estate. So I think that could be very helpful. I think you should continue the dialogue with the fund in terms of some of these drafting techniques and what might be possible in the future. Because again, if we haven't had litigation in the last 20 years, I'm not looking for it, and none of us are, but it gives us some idea that maybe we're being a little too conservative and maybe we can do a little bit more in the drafting process. I've included an appendix for you that has all the articles and the references that I used in putting this material together. You may get a different interpretation of some of these articles, but you should read them and then go back and read the material. And I just want to thank the fund for inviting me to speak here today, and I want to thank you all for getting up early to come and listen to me. Thank you.